on Facebook.
Okay, what about the other channels?
Okay, we're live now on both.
Okay. Good afternoon, ladies and gentlemen. Thank you for joining our podcast. This is Dr. Olu Asekun here. Please remember to invite your friends, family, colleagues to join us as we continue with our weekly podcast. So, we are. Thank you. Thank you for joining us. As usual, we'll start with the update before we go into questions and answers. As we are probably already aware, there is no shortage of updates under this administration. And the unfortunate incident that happened last week with the killing of the National Guard member, immigrants are now paying the ultimate price for that unfortunate crime. Between last week and now, as I said, there are several updates. We are trying to catch up. Some of them are very clear. Some are still very unclear. But I'm going to start with the ones that we know. On Monday this week, that is December 1st, 2025, the Trump administration fired 8 additional immigration judges. Judges that the administration believe are not doing their bidding. Immigration judges that they believe are not following the illegal order or specific following directive that they think is not right. So they fired 8 more judges, more immigration judges on Monday. Now, the second thing we want to talk about is that, again, as I said, because of the unfortunate incident of last week, the Trump administration announced sweeping immigration restrictions following the shooting of the National Guard. So many sweeping decisions were announced yesterday, December 2nd. I'm going to go through some of them. As at yesterday, December 2nd, the Trump administration said that they are going to halt asylum decisions for all nationalities, no exceptions. It doesn't matter where you come from. Every application for asylum, they are halted for now. There's a specific instruction to halt decisions. In fact, American Immigration Lawyers Association informed us that interviews are not paused, but that is, interviews that were previously scheduled, they will continue as normal, but no decisions will be made. They also said that new interviews may not be scheduled. Of course, we also don't know, as at this time, if immigration judges will be affected. So far, there is no notice from any immigration court that previously scheduled removal proceedings, asylum hearings will be halted. We have not had that. But even if they are affected, the hearings may continue, but decisions will not be rendered, because he has specifically instructed that no asylum decisions should be given at this time. So even if you have already attended an interview, there will be no decisions at this time, according to one of the updates. The second thing they did yesterday was that they have decided to re-examine all permanent resident grants, that is, all green cards that were granted to citizens of the travel ban countries. I will go over the travel ban countries, but all the green cards that were granted, it doesn't matter whether it is through asylum, through family petition, through employment based, every green card that was approved for citizens from the travel ban countries, they are going to be re-examined following the death of this National Guard officer. Now, again, December 2nd, yesterday, USCIS issued an order to all immigration adjudicators that they must not take final decision, either approval or denials, for all form types. That include student status, F1, H1B, L visa, R visa, green card application, employment-based, family-based, every form of immigration benefit, that all of them, all adjudicators, they must stop. They must not issue any final decision for any immigration benefit, including naturalization, that is citizenship. Even people that have been scheduled for swearing-in ceremonies for nationals of the travel ban country, they should not be sworn in according to the new directive, the new update. So if you are from one of the travel ban countries, even if you have been approved for citizenship and they have given you a letter to show up for swearing in, all these things should be paused according to this new policy. Now, let me go over the travel ban countries. The travel ban countries include Afghanistan, Burma, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, I don't even know which country is that. Turkmenistan, okay, and Venezuela. Now, some bloggers, or I don't even know what they will call them, they have been spreading misinformation about these travel ban countries. Somebody sent something to me yesterday on WhatsApp where somebody was claiming that Ghana, Nigeria, all these countries were part of the travel ban. This is completely rubbish. This is nonsense. That is not true. Nigeria is not included in the travel ban countries. Ghana is not included in the travel ban countries. So all those things, I mean, you know that some people are just looking for people, what do these social media people do so that people check their pages? I don't know what they call it, but they just want people to visit their pages. So they keep putting...
To create engagement or
Yeah, so they keep putting out false information. So those are completely untrue. So the travel ban countries, again, let me go over it. Afghanistan, Burma, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. So Nigeria is not one of the travel ban countries. So those who are spreading the false news, they should stop. And please do not be misled. Nigeria is not one of the travel ban countries. So many of these things does not affect people from Nigeria. Now, let me go into the next update. The Department of State also announced pause on visa issuance to citizens of Afghanistan. So anybody who is using Afghanistan passport, they have cancelled. Even if visas were already issued, they are cancelled. For those who are applying, they have been instructed not. The Department of State have instructed the embassy not to grant visa to anybody with Afghanistan passport. And of course, again, this is connected with the killing of the National Guard, because the accused person, the person who was accused of killing the National Guard, is somebody who was granted asylum from Afghanistan. And of course, we already know because of that, this is probably going to affect the adjudication of asylum in the United States. The next thing I want to talk about in the update this morning is that there's a case, there's a Board of Immigration Appeal case, BIA case, that is known as UTADO. UTADO. I talked about it in previous edition of this podcast when I stated that the BIA issued a ruling saying that anyone who entered the United States without inspection, they are subject to mandatory detention. Now, a federal court in a case known as Bautista versus Noem. Noem is the current Attorney General of the United States. A federal court stated that that decision to make Iwi entrance subject to mandatory detention is not legal, that the decision is illegal, and ordered DHS to start to allow people who entered without inspection to apply for bond. But American Immigration Lawyers Association informed us that immigration judges across the United States were instructed by the Trump administration to disregard the federal ruling, that they should continue to deny bond to Iwi entrant. I know this will be, somebody will be facing contempt of court, but I don't know at what stage that will happen, but that is what we have been told by American Immigration Lawyers Association, that the Trump administration has instructed all immigration judges to continue to follow the decision that Iwi entrants are subject to mandatory detention, even despite the federal court order. But I'm sure that this one will be resolved in a very short time, because I know somebody will be facing contempt of court for that. And I can assure you, this administration, the leadership, they are very good at evading all these things and throwing people working under them under the bus, as the current Secretary of War is doing now regarding the second shot that were filed on the allegedly drug carriers. Now, the Secretary is saying that he didn't give the order, that he was the commander. This is one of the reasons why some congressmen, some bipartisan leaders say that military men should not obey illegal orders. Now, the secretary is trying to exonerate himself and trying to throw the commander under the bus. Well, anybody who obey illegal order, they will have themselves to blame. But this is what Immigration Lawyers Association, American Immigration Lawyers Association, this is the information they have passed to us, which I'm sharing with my listeners. The next thing I want to talk about here is that, again, DHS has announced the termination of TPS for citizens of 80 citizens will no longer be eligible for TPS effective February 3rd, 2026. That's going to be in about 2 months' time. Effective February 3rd, 2026, they will no longer be eligible for TPS. And the last information I want to pass before we go into question and answer is that, again, American Immigration Lawyers Association notify us that Department of Health and Human Services and Medicare and Medicaid services, they are now sharing information with DHS. So in other words, if you are not a citizen and you apply for either housing, maybe food stamp, maybe Medicaid, Medicare, even if you are applying for your American citizen child, although your children may still be eligible, they may qualify to apply. But remember, even when you apply on behalf of your children, you are still going to put your information as the parent. Now, those information are being shared with the Department of Homeland Security. So if you don't have papers, I will advise you to stay clear of all these things so as to avoid being in trouble with this administration. Now, let's go into questions. I'm sure we already have lots and lots of questions. Is that the first one? Okay. Hello, doctor. What is this all about regarding the government freezing all asylum application and cases? Will the government not attend to all pending cases and stop receiving new applications? For now, they will continue to receive new applications. They will continue to process applications, but the instruction, the policy says that they should not issue decisions. That is what they say, that they should not issue decisions. Now, let me read it again. On December 2nd, which was yesterday, AILA, that is American Immigration Lawyers Association, learned that USCIS has now issued an order to all adjudicators to pause final decisions, that is, approval or denial, for all form types. This is not only asylum. Every single case for citizens of the travel ban countries. This is all forms, even including citizenship, including naturalization, even including swearing in ceremony for those who already passed and those who have already completed the process. Everybody is affected. The decision is that they should not issue any decision right now. So this was an order that was given to all adjudicators. So, but it is not clear whether this affects immigration judges, but the order was directed at USCIS adjudicators. That is officers, supervisors, either junior, senior officers, or all USCIS employees that adjudicate cases. They have been given specific instruction to pause decision so they can continue to, well, it is not clear whether new interview letters will be sent out, but at least those who have previously been scheduled for interview can still attend their interview, but they will not get any decision for now. I believe that the Trump administration is preparing a new adjudicator manual, what they have to look at before deciding whether to approve a case or deny a case. But for now, there should be a pause. That is what the decision says concerning that. Next question.
This is the same person. Second question.
Okay. Also, does this help some asylum cases? Because someone was saying that these situations will help those with weak applications or cases. Yes, it may help them because normally if they issue decisions and they deny it, they will place them in removal proceedings. But now, if the decision is delayed, yes, it may help them. I mean, it will give them help them to buy more time. Of course, it's not going to change anything because I'm sure that by the time they resume, they're probably going to come up with more stringent conditions. So weak cases will still not stand a chance, but it's going to be a temporary relief in that they will be able to buy more time. Next question, please. Dr. Olu Asekun, happy new month of December 2025 and to all your crews. Thank you. Happy new month. Move to the next one, please. Please, can you give me audience through WhatsApp? I want to make an inquiry.
We don't have one, but you can give him the office number, or we can just post it on the chat.
Okay. Respond to that person. Please go ahead to the next question, please.
Okay.
Good day, doctor. Does this affect immigrants from Sierra Leone? Did I mention Sierra Leone?
Yes.
Yes. The travel ban countries, they are Afghanistan, Burma, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, Yemen, Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. Yes, Sierra Leone is affected, meaning no immigrant visa is on. Yeah, every kind of visa is on hold for all those travel countries. Everyone, even including citizenship, everything is on hold. Okay, move on, please. Move.
That's the one. The plenty grace.
Yeah, move it up because the red. Okay. Yeah, one of three. Good day, sir. PD for I-130. What does
Prosecutorial discretion?
for I-130?
There's none, right?
I don't understand some of these abbreviations. People try to.
It said I-130, I-45, and I-765. Okay, no.
Oh, maybe priority date.
Yes.
Yeah, priority date. Okay. Okay. Priority date for I-130, I-485, and 765 was June 23rd, 2025. I-130 approved on the interview day, October 8th. Birth certificate RFE issued under I-485, 10/14, October 14. I responded online the following day, October 15. My I-765 is still pending till now. Based on my I-765 case processing timeline, I checked and it says the earlier date I can contact USCIS is December 6 if no action is taken by then. Sir, my question is, if no action is taken by that date, can I contact USCIS by filing a service request on the I-765, or is it advisable to do that? If yes, how effective is it? Thank you. Oh yes. Yeah, service requests are effective if after the timeline given, you have not received a decision on your case. Yes, you can do a service request. It doesn't have any negative impact at all. There is no negative impact to a service request. You can do it. Yes, it doesn't have any. It is advisable. In fact, usually that's what we do when cases are delayed. So it doesn't have any negative impact. Go ahead and submit a service request if you have not received any decision. Go ahead. Next one. Okay. May the Lord bless you and your team for this invaluable help. Amen.
Amen.
Does the asylum pause affect asylum that has been granted by immigration judge and the immigrant already has I-797 AOS receipt? Yes, it will affect the 797 AOS receipt, especially if you are from one of the 19 travel ban countries. However, it cannot affect asylum grant by an immigration judge because immigration judges, they are not part of the DHS. They are not under the Department of Homeland Security. So normally, when USCIS deny asylum application, they refer you to an immigration judge. So in a situation where you have presented your case in court and your asylum was granted, I can assure you that you are not going to be affected. That one is a judicial grant. It is different from the affirmative grant or affirmative decision. So all these administrative decisions affect administrative grant of asylum. But the way it will affect you is the processing of the green card itself, because everything has been put on hold right now, especially if your green card is based on the grant of asylum. Yes, it will delay the grant of the green card, but I don't see your asylum being affected if your asylum was granted by an immigration judge. Because if an immigration judge granted you an asylum in court, the DHS, they have the opportunity to appeal if they disagree with the decision of the immigration judge. If you are a regular listener to our podcast, you will see that I've been mentioning on this podcast that since Trump administration came into office, every asylum grant that I got approved at the immigration court, the DHS has filed an appeal, even including the one that I announced here recently, that I have this very contested asylum case. I came back the following week to announce that, yes, I got the asylum approved. But I also want to tell you now that DHS has filed an appeal. So the point I'm making here is that once an immigration grants an asylum, both parties have 30 days to file an appeal if they disagree with the judge. So in this case, if the judge granted you asylum, DHS has a right of appeal within 30 days. If they didn't file an appeal within 30 days, your asylum is gone. You are granted. There's nothing they can do. It is too late for them to do anything about it. But that is different from when an affirmative asylum is granted by a USCIS officer. Because number one, you don't even have any right of appeal. It's either they grant it or they send you to removal proceedings. Because it is an administrative decision, they can still revisit it. They can still reopen the case, which is what they are trying to do. So if you are granted by an immigration judge, I can assure you your asylum is secure. But it will still affect you because every green card application that is based on asylum is also on hold. So it will delay the grant of your green card, but it will not affect your asylum. Next question, please. Hello, sir. Kindly advise. I'm an EB4 applicant with pending I-485, awaiting adjudication with February 2023 priority date. My 5 years R1 validity will expire by January 2026. I have approved EAD. No, I think you missed something, or is that from a different person? Oh, okay. Can I take up circular employment post R1 expiration while maintaining my religious work concurrently? No, sir. The categorical answer to that is no. It's not even close. If you are a regular listener on my podcast, whenever I answer religious questions, religious related questions, I always emphasize that religious workers, the law that established R1 and 360, that is the only law that used the word solely, SOLELY, solely. It means you cannot do anything outside of the religious employment. And I can give you 1,001 examples of flimsy things that immigration has used to deny green card. Not only to deny green card, but even to revoke the approved 360 and even the R1. Let me give you one example. Somebody with an approved R1, approved 360, a pending 485, with employment authorization, was doing business. He decided to export some things out of the US. Unfortunately, these things were intercepted by custom at the airport. So he went to the airport to go and find out what was going on. They asked for his ID. So he provided his ID, they pulled it, and they realized that he was a religious worker. And they said, you are not even supposed to be shipping anything. Long story short, they went back, USCIS revoked everything that was granted to him. We challenge this decision, we appeal, they deny it. I even remember going to court to challenge immigration, but they kept on pointing to this word solely. And when you look at Immigration and Nationality Act, it is only under religious worker that they use this word. So you are coming to the United States solely to work for this religious organization. So you are not permitted to work for any employer, at least until you get your green card. When you get your green card, it's a different ball game. A permanent resident is a permanent resident. It doesn't matter how you get it. You can work you can do 2, 3, 4, 5 jobs. It's not going to matter. But for as long as you are still relying on this R1 category, you cannot do something else. Next question, please. God bless you and your team, sir. Amen. Is it true that green card holders can't travel unless they get permission from the government? Blatant lie, sir. That is not true. There's nothing like that. Good day, sir. Okay, let me revisit that question. That question that says, is it true that green card holders can't travel unless they get permission from the government? The simple answer to that question is no. There is no such thing. However, what I wanted to add is that because it may be, you see, when people pass information, they may be passing out information. It may be what the person is talking about, whoever is telling this person this thing, what they may be talking about is somebody who has a green card and is planning to travel out of the country for an extended period. Yes, if you are a green card holder and you are planning to travel out of the US for an extended period, yes, you need permission from USCIS. You have to give them notice that you want to travel for an extended period. So they give you re-entry permit. So that way you don't lose your green card. Because if you travel without doing that for an extended period, the presumption of law for any permanent resident who travel out of the United States for 12 months or more, the presumption is that you are abandoning your permanent residence. So in order for that presumption not to apply to you, you may need permission from the government before you travel. That is the only exception. So I wanted to clarify that. That may be where the confusion was coming from. Please go to the next question. Good day, sir. I was able to reopen my removal in absentia order case. I was at the court on 29th October 2025 and the judge said January 7, 2026 for my master hearing. I had initially filed I-130 in March 2025 and submitted as part of my relief documents to the court before my case was reopened in June 2025. The I-130 is still pending. My lawyer said I should file my I-485 with the court before January 2026, my next hearing. Is this possible? He also said I will pay $1,440 and additional $1,500 to the court, $2,940 before I can file the I-485 with the court before January 2026. My next hearing. Is this possible? He also said I'll pay $1,440 and additional $1,500 to the court. Oh, did he repeat this? So. Okay, before I can file the I-485 in court. Is this also correct? Yes, all of the above are correct. They are correct. It is possible for you to file the I-485 with USCIS with the $1,440. However, because you are in removal proceedings, this is one of the new fees that this Trump administration introduced. Before now, you don't have to pay any extra fee in court, but under the current administration, they introduce all these fees under the big, beautiful bill. I mean, this administration is really milking immigrants. At the same time, also going after them. I mean, you are collecting money from people and yet you want these same people to be deported. I don't get it, but unfortunately, that is what the administration is doing. So all these things are true. Next question. Good afternoon, sir. Please do the Trump asylum stuff after someone that was granted by court. No, I think I already answered that. I already answered similar question. If you are granted asylum by an immigration judge, all these things will not affect you. For as long as you DHS did not appeal when the court granted it, they have 30 days to appeal. If they didn't file an appeal, there is nothing they can do. You are safe. I mean, there is a principle in law called res judicata. So once a case is granted and your appeal period passed, the case is over. They can't revisit it, except you do something that takes you back to removal proceedings. Because when I say they can't revisit it, it doesn't mean that if you commit a crime, they cannot revisit it. If you commit a crime, they can still place you back in removal proceedings. And then, of course, if you reapply for asylum, that will give them an opportunity to revisit it. But in the absence of you committing a crime, in my language, Otijelo, how do you say that in English? I don't know how to say that in English. Otijelo. How do you say that in English? Well, I don't know. If you understand my language, you probably, I mean, you have received it. You have received it. There's nothing they can do about that. So, okay, let's go to the next question, please. Question 1 of 2. Good afternoon, sir. My adjustment of status for self and family was rejected after bank declined my debit card and for suspicious activities. How long does it take to return the form? EB2 self-petitioned applicant. Well, unfortunately, USCIS is in the habit of sending documents with regular mail. They don't mail documents with priority or even certified, except if they want to mail green card. If they want to mail green card, yes, they do mail green card with priority mail. But rejection, I can guarantee you they are going to send it in by regular mail. So sometimes it may take you up to a month before you receive it. So if time is of essence, if you know that time is going to be a factor in your case, I would suggest that you refile, prepare a brand new one. The only problem is you may not be able to include the medical, or you may have to redo the medical, or maybe go back to the same clinic where you did the medical. But normally it may take up to a month before you receive it. I would say 3 weeks to 4 weeks before you receive it. If time is not of essence, just wait for it. And again, it is not advisable to use a debit card. That is what happens when you use debit card, because most of the time, the bank may think that somebody is trying to commit some fraud on your account. So they may want to verify it, and immigration charges come any time of the day. It can come at 1 a.m. It can come at 3 a.m. It can come at 6 p.m., 10 a.m., any time of the day. So if it comes at the time that the bank is trying to reach you and they are not able to reach you, they are going to decline. So it is better. There are 2 options you have. Either you use a credit card, which will not require verification, or you give the bank prior information. Look, I'm expecting X amount of charges on my credit card or my debit card. So give them the advance information and tell them that the charges is going to be coming from the U.S. Department of Homeland Security. So that way, the bank may not need to call you if you already give them advance notice. Because even if you refile, if you don't take care of that, they will still reject it. Next question, please.
Do you read that 2 of 2? Well, of course, you already
Oh,
answered
2 of
it.
2. Okay, let me see.
You already answered it, but just in case.
Oh, okay. Yeah. It's
So,
the same thing. I already
What
answered
you
it.
said in Yoruba, somebody saying that it means you have scaled through.
Okay, yeah, Otijelo, yeah, that's the right word. You have scaled through. So if you are granted asylum by an immigration judge, Otijelo for this this thing, so there's nothing you have scaled through. So you can't you can't be affected by this all this thing going on right now. Now, the next question. Good day, the Attorney General of the masses. And his great team. Thank you. God bless you all richly. Amen.
Amen.
We submitted our I-130 in April 2025. We attended interview May 2025. USCIS requested RFE.
I don't see a second question for the same person. Do you?
What's the name again? Go back, let's see the name.
I don't even see that one on here.
Okay, you can scroll down now. Let's see.
I did. There's nothing.
So there's no
I don't
follow.
even see that one on mine. They must have deleted it.
Okay.
That's what I'm trying to see too, but I don't see it.
I don't see it.
Well, in the
You know
absence of a question, there's
Yeah.
nothing to answer. So let's go to the next one. If you find it later, call my attention to it. I will go back to it.
Okay. I think the next one is this one.
This one. Okay. Sir, 2 weeks ago, you said something about USCIS visiting questioning former spouses after green card has been approved. Will they do this to VAWA spouses as well? I know somebody asked me this question earlier. I don't know whether it was today or something. Well, let me say this. In as much as we are trying to provide information, there are some things that are outside my knowledge, my authority. I cannot tell you specifically what USCIS will do or what they will not do. What I know is that we report the trend that we observe. We rely on information that is provided by American Immigration Lawyers Association. We rely on experience, personal experience. We rely on what happened in court. We rely on policies that are announced by the government. We rely on case laws, all the things that we know. But there are some things that we don't know. As at today, I don't know whether VAWA will be affected or not as at today. But one thing I do know is that VAWA is treated differently than the way these other cases are treated. Number one, VAWA is treated with confidence. It's a confidential application. VAWA is not an application that every USCIS officers have access to. No. A lot of USCIS officers do not have access to VAWA. That is why it is difficult to get somebody to talk to you over the phone when you have a pending VAWA. Because when you call USCIS, the person who is going to answer the phone does not have access to your VAWA file. Unlike other cases, regular cases, a US citizen petitioning for somebody, an employer petitioning for somebody, any other application, when you call them, they are able to pull the case, but they are not able to pull VAWA. That is one. However, in my experience, have I seen a situation where VAWA case was investigated? Yes, I have. I can give you one example. I remember I handled a case sometimes back. The VAWA office issued an RFE. In the RFE, they stated that when they contacted the landlord, that in relation to the lease agreement that was submitted, When they contacted the landlord confirmed that this person was not on that list, meaning that the lease agreement that was submitted was forged. What does that tell us? That tells us that sometimes they do contact, they do verify some of this information. They do verify documents that were submitted. So the fact that you submit a document to VAWA, even if VAWA is treated confidentially, it doesn't mean that they are going to accept your document just like that. They do verify documents. I know that for a fact. I know that based on experience. I've seen another instance where the VAWA office issued an RFE and they claimed that they contacted the apartment and the apartment provided them a copy of the lease agreement, and that the lease agreement provided by the apartment is different from the lease agreement provided by the applicant. In another case that is similar, they stated that VAWA office issued an RFE, and in their RFE, they stated that in the lease agreement that was provided, the applicant's name or the petitioner's name or the abusive spouse name was added with pen, was added to the lease with pen. And when they contacted the apartment claimed that they don't issue any lease that is written with pen. So that must have been a forgery. When in reality, it was actually the apartment that wrote that thing with pen. So when USCIS, when VAWA office issued that request for evidence, I contacted my client. I asked my client, could this be possible? Who used pen to write this? They said, no, it was the apartment. So we contacted the apartment. I wrote a letter as a lawyer to the apartment that, look, I'm writing this letter on behalf of my client. I want to see a copy of the lease agreement that you have in your record for my client. So the apartment provided a copy of the lease. They provided it to me. And guess what? The same copy that they provided has the handwritten note. I now send them another letter. If this is what you provided, this is the same one that USCIS contacted you about, and you told them that you don't issue handwritten document. So why did you lie to USCIS? In fact, in that particular case, my client filed a lawsuit against the apartment. I'm not even sure if the lawsuit is still pending or has been settled because I didn't represent him. I don't do civil cases, so I refer him to another lawyer. But I do know because a copy of that lawsuit was part of the document we used to respond to the notice of to the request for evidence, and of course the case was approved. But my client still went ahead with the lawsuit, even despite the fact, because you can't tell USCIS that this thing was forged when you are the one that wrote it with your own handwriting. So what are we saying here? Do they check these things out? Yes. Are they going to go back to the abusive spouse? That I don't know. I don't think so, but I don't know. I mean, as at this time, we don't know. If at any point I become aware of that situation, I will come back on this podcast and update us. But as of today, I don't know if they will go to that length. But I don't think it will be a smart move. But this administration has been known to do a lot of unconventional things. So we can't guarantee that they will not do it. But so far, I don't have any information whether that will be done or not. Next question, please. I intentionally spend a lot of time answering that question because I remember somebody else has asked me this same question. So there may be multiple people who may be looking for answer to this. That is why I spent a lot of time answering that question. Okay, next one. Good afternoon, sir. Do this Trump stuff affect someone who is anyway granted in court? Yeah, I've already answered that extensively. If you are granted asylum in court, you have no reason to be concerned. That's when we use the word otijelo. So that has been answered extensively. If you see any such question, you can skip it. I've answered that extensively. I mean, if anybody doesn't remember, they will remember otijelo. And I'm sure that's a new vocabulary for you guys.
It is.
Otijelo, you scale through.
You scale through.
So, good day, sir. Thank you for all you do. I heard about a new status approved last week, some days before Thanksgiving, special immigrant juvenile status. I have a 23-year-old niece that was abused and
I think he's neglected.
neglected. Okay. Do you think my niece has a chance, considering she has some stories from their home country and also here by her mom, husband? Thanks, sir. No. Number one, SIJ is not something new. SIJ has been part of the immigration law for years, for several years. It's not something new. But secondly, your niece is not eligible based on the information you have provided, and primarily based on the age. Your niece is not eligible. To be eligible for SIJ simply means special immigrant juvenile. Number one, a 23-year-old is not a juvenile. Anyone under 21 is a juvenile. Number two, to be eligible for SIJ, special immigrant juvenile, the applicant must have been abused or neglected, or you must have shown that it is not in the best interest of that child to be reunited with the biological parent. Now, SIJ is not something you go to USCIS and file. The first step, you go to a district court. You go to a court and you file an action in court, and the court will be the one that will determine that this child has been abused or neglected, and that it will not be in the best interest of this child to be returned to the biological parent. So the court can now appoint what is called a guardian ad litem to take care of this child. The court can also appoint a private person, especially if you are the one going to court on behalf of this child. The court can appoint you as the guardian of this child. But the most important thing is that the court must find that this child has been abused or neglected, and that it is not in the best interest of this child to be reunited to the biological parent. But this decision, all these things must happen before the child turns 21. It is not something you can do after 21. So now, assuming you are able to get the court to give that order, confirming that yes, it is not in the best interest of the child to be returned to the biological parent, it is that court order that you will now use to apply for SIJ petition for this child from USCIS. So that is what SIJ is all about. Next question, please. Good afternoon, sir. God bless you and your team. Amen. Sir, what is the consequence of not informing USCIS of your change of address if you have a pending asylum petition? Yeah, the consequence is big. Number one, if you have asylum application pending before USCIS, if you are a regular listener of our podcast, you will see that I've explained it on this podcast several times that USCIS, when it comes to asylum, their authority is one way. They do not have the authority to deny an asylum application. Their authority is, if they believe your story, they approve it. If they don't believe your story, they send you to a removal proceedings. They issue a referral notice and send you to a removal proceedings. Their authority does not include denial. That is why if you have ever received a referral notice, they will state clearly in your referral notice that this is not a denial of your application. All they are telling you is to go and represent your case. before an immigration judge. Now, if you move and you did not provide a change of address, if USCIS decide to refer your case to an immigration judge by issuing a referral notice and issuing NTA, the NTA will be forwarded to your old address. When the NTA is filed with the court, hearing notice issued by the court will be forwarded to your old address. So at the end of the day, without you receiving this document, you can be ordered removed in absentia. And then what happened? One day you may be driving and they can just stop you, and from there you get into ICE detention. Sometimes you may even be deported before you find out what is going on. Because once there is a removal order, you are at risk. So it's not worth it. If you change your address, provide a change of address to USCIS, because not doing so can adversely affect you. It can create a problem for you. But that is the only thing. Other than that, there is nothing else. Next question, please. Okay. Does the new decision also affect asylee going through court proceedings? Well, I stated that we don't know that for now, because the pause. What?
I highlighted the one on top. I was going to skip this one because you already said that you answered. Somebody just
No, this is a different question. This one has not been granted.
Okay.
This is a different question. That's why I'm answering it.
Okay.
I'll come back to that one. Does this new decision also affect asylees going through court proceedings? If you that I don't know yet. Remember when I was reading the update, I stated that even American Immigration Lawyers Association said that they don't know how courts are going to, whether the court will be affected. What I do know is that if you are in a removal proceedings, the cases will proceed. If the courts are affected, they will not be able to issue a decision on your case, but the proceedings will continue. But whether they will be able to issue decision or not, that is not something that is clear right now. We don't have answer to that right now. But as soon as we become aware, I will come back on this podcast and update us. Yeah, now you can go to that question.
They're just greeting you.
Okay, good evening, sir. Yeah, good evening.
There's another one.
Yeah, good afternoon, sir. Yes, good afternoon. How are you today? Okay, legal entry. I-130 approved. Asylum pending. Asylum pending BIA. Can I admin close, reopen so I can use existing work permit? Please advise. Okay. I'm assuming that the asylum has already been denied, because if it is not denied, you cannot even get to the BIA level. BIA is Board of Immigration Appeal. So it's an appeal case. Now, if your case is still pending with the BIA and now you have an approved I-130, my brother or my sister, whoever sent this question, time is not your friend. What you need to do right quick is what is for you. Tell your lawyer to file a supplemental brief with the BIA and let the BIA know that you have an approved I-130. In the supplement filed to the BIA with the BIA, they should request that the case should be remanded for you to have the opportunity to apply for adjustment of status. You should go ahead and file Form I-485 so that you get the receipt notice, you pay the 1,500 fee, and you file it together with your motion for remand. You should file a motion to remand with the BIA for you to have the opportunity to present a new relief that was previously unavailable at the time of the initial trial. The reason time is of essence is that if you go ahead and allow BIA to take a decision, if that decision is not favorable, it will be too late to ask them to remand it. It will be too late. So now that the case is still pending, tell your lawyer to file a motion to remand, to file a supplemental motion to remand with brief and ask the BIA to remand the case back to the immigration judge to enable you apply for adjustment of status, a relief that was not previously available at the time of the initial trial. That would be my advice. Next question. God bless you, sir, for all you do. Amen. I was the one who asked if work authorization can still be renewed for SIJ and if new ones are still being issued. I know there was a news concerning SIJ recently, about 2 weeks ago. I can't remember right now.
They weren't issuing
Amen.
new renewals for the EADs. They stopped the renewals.
Yeah, I think they stopped issuing renewal for SIJ. And I also know that there was a recent policy that all SIJs should be halted and they should be reviewed because there are a lot of fraud. I mean, there are people who bring their children to the US and then leave them with a family member and then go ahead and file SIJ without any proof of abuse or abandonment and all kinds of briefs. So I know, what's that?
It's like the city and the alarm.
Oh, okay. I just want to be sure it's not within the office.
No.
Okay. Yeah, so yes, they are not renewing EAD for SIJ right now. That's the reminder that I got here from my team members. But I do know that you can go back to play our podcast in the last 2 weeks. I remember there was something on SIJ. You know, I'm not a computer. It's not everything that I can remember. And besides, I'm getting old. So many of these things, I have to write them down now. The only thing I don't forget is the law. I mean, I know the law. I can't forget that. But when it comes to policies, yes, especially with these new policies that are going almost on daily basis, we are struggling to catch up. There are too many things to remember. So next question, please.
This is the second question from the same person. Let me just show it to you. This one.
Okay. Is it what is the processing time for VAWA and also for SIJ? Well, these two, can you check I-360 VAWA, the processing time? Since that is just about processing time, go to the next question. Once I have the answer, I will go back to it. Good morning, sir. My mom entered on B2 visa and overstayed. I'm now a US citizen. Can I safely file the I-130 and I-485 together for her at this time? Oh, yes, you can do it. Your mom is perfectly within the definition of immediate family of a US citizen. Yes, go ahead and file I-130, I-485, and I-765, I-864. Go ahead and file it for your mom. Yeah, you are in good position.
SIJ is 36 months, so 3 years.
SIJ, the processing time for SIJ is currently 3 years, 36 months.
VAWA is 44 months.
VAWA is currently 44 months. That's the processing time for those two applications. Okay, next question. Came in with K3, divorced, never completed the process, remarried over 10 years. My I-130 just approved and was told to file I-485 and AOS since I will be needing I-601A. At what stage should this be? Should I get my I-601A approved first or apply for I-485 and AOS as suggested in the email sent after my I-130 approval? Which one comes next, considering the length of the I-601A takes 33 months? First and foremost, I don't know who sent you that email. That email is not accurate. That is not the law. If you enter the United States on a K visa and you divorced before you get your permanent resident, statutorily, you are ineligible for adjustment of status in the United States. If anybody tells you otherwise, they are lying to you.
So it's also for K3? I was thinking it was only K1.
Go back to the question.
It's a K3.
Because he came in on the marriage. If it's a dependent, you cannot be talking about marriage.
No,
Or maybe I didn't read the question correctly.
remember K3 is when the US citizen files for the spouse, but they want to bring him earlier. So then they also file the I-129F together. Remember? We used to do this. K3 before.
No. The one you are talking about, that one was specifically for children of permanent residents whose cases were getting extensive delay.
No. Remember the two brothers that they both got married in Nigeria and they both filed for the spouses, but we actually filed K3s. One of them proceeded, the other one not because of the background on one of the petitioners.
If what you are saying is true, why will a waiver be required? Because K3 is a legal entry.
Yes.
So why would they need a waiver?
I don't know.
That's why I'm telling you.
No, that's why I was asking you if K3 also applies. I was thinking it will only apply for fiancé.
Can you verify that? Skip that question. I'll go back to it.
Okay.
Yeah, I'll go back to it. Please go ahead and verify that.
Don't worry. Hold on 1 second, because some of those questions were withdrawn by the user or your watchers.
It may be that I've answered what they.
I don't know, but she's done it twice, so maybe she doesn't want it to be read.
Okay, I'll come back to that question because I want to be sure that whatever information you are getting here is 100% accurate. I don't want to give you half information. I'm not one of those people that will give you misleading information. So I want to give you accurate information. So while we are checking that for me to be sure, I will answer the next question. Hello, doctor. Thank you for your good job with your team. My sister's I-360 was approved since June, and her I-485 status changed since September. So case is ready to be scheduled for an interview. Is there okay, I think the next one is continuation. Sir, is this a good sign, and how long will she wait before she got her interview scheduled for decision? Well, yes, it's not about sign. That is the procedure. I'm assuming that this I-360 was VAWA based, because if it is not VAWA, then it means it is employment. It means it's a religious worker. So even though the question didn't clarify that, so I'm going to answer it both ways. So if it is VAWA, yes, that is the normal process. It is not. There's nothing to be afraid of. Normally, VAWA is treated differently at a VAWA office in Vermont. So once a VAWA petition is approved, the approver and the I-485 is then forwarded to the local office where the applicant will be required to attend an interview. So this time, the interview is going to be based on the I-485 application for green card. So this is where they will check whether this person has any criminal record, whether this person, whether the medical examination is clear, or there is any form of inadmissibility issue. If there is none, after the interview, usually the green card is approved. Now, if this I-360 was based on religious worker, there are two options. The green card may be approved without interview. On the other hand, interview can be conducted. Employment-based interviews are not usually, employment-based petitions are not usually invited. Employment-based applicants, are not usually invited for interview. It was only after Donald Trump administration came into place that he insisted that interviews should be conducted. But even at that, once in a while, we still get cases, employment-based cases approved without interview. But that is what can happen. But if this is VAWA, interview is mandatory. That is the procedure. I think there's a third question. Or is that a second one? Oh, that's a second one.
No, that's it for that person.
Okay. Do you have an answer?
Yeah, what Marissa was saying is true. The K3 visa is when you have a K1 pending, but then you get married to the spouse and it allows them to
No.
temporarily enter.
A U.S. citizen is already married
Yeah.
to the beneficiary,
Uh-huh.
who is abroad.
Uh-huh.
They file the I-130. But in order to shorten the waiting period or the separation between them, then they can now file another.
I know that. What I'm saying is, the moment what happened to that petition, the moment you divorce that person who brought you in with a K visa.
So it is revoked. If the I-130 has already been approved, it will be revoked, but it does not change the legal entry. So that person is free to remarry, but of course they will have to refile through the new spouse. But the K3 is revoked.
So why is I-601 necessary? Why is the waiver necessary?
I don't know why they told him that, because this is information he's giving you. We don't know if it's the real requirement.
Well, maybe what I'm going to suggest is that, I mean, if the person asking that question if they can call the office immediately after the podcast, I will answer the person. I will be able to ask more questions because there are so many technical issues here, and I don't want to provide a wrong answer because K1 is one of the most technical form of applications. If this person came into the United States with a K3 visa, so I want to know, why do you need a waiver?
I don't think he does, honestly.
Why do you need a waiver? So either way, the information provided here on this podcast is not accurate. The questions here, the information provided in this question, I'm certain that information is not accurate. Because if it is either you have to go back to your home country, which align with my position that with a K1 visa, you cannot get green card through another spouse. So you have to return to your home country. And now, because you have been here for an extended period, you are probably already out of status. That is where the issue of waiver comes in, I-601. But even at that, you are still not eligible for adjustment of status. You still have to go back to your home country. So the only reason you are filing the I-601A is unlawful presence waiver. So that when you go back to the embassy in your home country, they will not use that overstay against you to deny you visa. That is the purpose of the I-601A waiver. So if my position is not accurate, I want to know, why do you need a waiver? So if you are the one who asked this question, call the office immediately. We get over this. We stop this podcast. Before I go into something else, I will answer I will be able to ask you more questions and be able to answer it. But generally, for the purpose of listeners, all our supporters, all our followers, my position has not changed. K1 visa requires that you get green card only through the petitioner who brought you into the U.S. If you are divorced and you remarry, you cannot get green card in the U.S. Even if you marry Donald Trump's daughter or son, you cannot get green card. That is the law. Until the Congress change it, that is the position of the law. That has not changed. But what I want to know now is the issue of the K3 versus K1, because K3 is when you already when you are already married and you file I-130 petition for your spouse, but the process of that petition is taking long, and you decided to apply for K3 to bring in your spouse into the U.S. So if my team member's position here is right, then you don't need a waiver. So I want to know why you need a waiver. So if you call the office, I'll be able to ask questions and then we clarify that. Next question, please. I got my 2-year green card in 2019. After that, I got the 48-month extension letter, and now I have 1 year 551 stamp, which that will expire in September 2026. Please, can I travel to Nigeria waiting on response on interview? Yes, if you do not have criminal record, yes, you can travel. Everything you mentioned is still okay. However, as I always warn people, every case is different. There are no two cases that are the same. This question didn't tell us whether the 751 was self-petition or whether it was joint petition. Because I want to be sure that when you get information on this podcast, the information is accurate. I don't want to mislead anyone. So that is why it is important that you provide accurate information in asking questions. I don't know if this is self-petition or this is joint petition or this is based on good faith marriage. Those are three scenarios that we don't know. Now, why is this important? It is important because if this is a joint petition, before you travel, make sure that you put your house in order. What do I mean? I've said it on this podcast several times. There have been scenarios where people travel and they are coming back. Meanwhile, they have their petition or their green card or conditional green card is based on marriage to a U.S. citizen. They are coming back at the port of entry. They ask them questions about their spouse. Oh, where is your spouse? Oh, my spouse is at work, or my spouse is at work. We have seen situations where the CBP officer pick up a phone and call the wife. They ask the wife, where is your husband? And the wife said, my husband is at home. Remember, this guy is at the airport trying to re-enter the U.S. So the wife didn't even know that he traveled out of the country. So what kind of marriage is that? That in itself is a major, major problem. So there are no two cases that are the same. Make sure that you put your house in order if you must travel. But can you travel? Yes, for as long as you don't have criminal record. If you have criminal record, my answer changed to no. Next question, please. Thank you for this program. My question is, please, any new update regarding J visa 3-month single entry for exchange scholars in the United States? There is no, to the best of my knowledge, there is no, have we said anything about J visa recently? I'm not aware of any recent changes. The only thing I can tell you is that anyone granted J visa have what is called 2-year foreign residence requirement, except there are two exceptions. Generally, if you enter the United States with a J visa, by law, at the end of the period of authorized stay, you must return to your home country and spend minimum of 2 years before you can come back to the U.S. So all J visa have that. But there are two exceptions. One, if your visa is not required, if the 2-year foreign residence requirement is not required, they will write it on your visa. 2-year foreign residence waived. It will be written, it will be annotated on your visa. That is the first exception. The second exception, you can actually apply for an exception to this 2-year foreign residence requirement. That will require you to get a no objection letter from the embassy of your home country. So if you are from Nigeria, you get a no exception letter from the Nigerian embassy in the United States, in Washington, D.C. If whatever country you are from, you have to get a no objection letter. And with the no objection letter, you apply for a waiver with the Department of State. So the first thing you do is go and look at your visa, your J visa, look at it. Did they give you any exception on it? Did they annotate anything that says that the 2-year foreign residency is not required? If the answer is no, then it is either you go back at the end of the period or you apply for a waiver of the foreign residence requirement. Next question, please. Yes.
The only kind of update with J1 was DHS was proposing that they end the DS, the duration of status, and do it for like a fixed amount of time, but that hasn't even been implemented yet.
Yeah.
Yeah, so I don't know if that's what they mean, but
Yeah, that's why whenever we release an update, we talk about what they are planning versus what they have done. So if they have not done it, it's not an update. So there's no update yet.
yeah.
Next question, please. Hi, good afternoon. Good afternoon. Oh, that person didn't ask question? I didn't see a question.
I didn't see it either.
Okay. Good day, sir. Just want to thank you and your crew for the good work. God bless you, sir. Amen.
Amen.
We already answered to that one.
Okay.
This is a response from Kim.
Okay.
This is the person that you skipped, that you asked her to call after the podcast. Okay, so this lady right here.
Please, I need help. So what's the question? Good day, sir. Is it the...
Yes. We'll come back to the one that we just skipped.
No, there's one immediately above this one.
Yeah, that's the one that we're gonna go back to it later. Because this is the same lady that said, hello, I need help.
Come back a little.
This one,
Okay.
this is the second question. Or
Oh,
the
okay.
second message.
Okay. Good evening, sir. Please, I have submitted all my documents to NVC and I'm qualified. My husband is a US citizen. I'm in Nigeria. My husband is seriously sick and needs help. I don't have US visa to travel and help him. What can I do? Should send an SMS to NVC. I'm worried and I need to take care of him. Well, this person didn't indicate whether he has a lawyer or not, because if not, he will have to do it herself. What I want to suggest is to file expedited request with using the husband's medical report, to file expedited request with the National Visa Center using the husband's medical report. But if you have a lawyer, just reach out to your lawyer and let your lawyer know that your husband is sick, and then try to get the medical report, and then your lawyer can submit expedited request with NVC, because sickness is actually one of the things that they can consider when they are looking at expedited request. So you can submit expedited request to the NVC, but you need medical report to confirm, to verify that your husband is actually sick. Good day, dear sir. We appreciate the great work you are doing. Thank you.
This is his question.
Good day, sir, and thank you for the great work you are doing. Thank you. Please, how long can someone on H-1B visa of Nigeria origin wait after his company has filed for green card to get the green card? Well, this is an employment-based question. You have to know, we don't know the category, because H-1B transitioning into green card could be under EB2, it could be under EB3. So we have to look at the visa bulletin. We need, for me to answer this question accurately, for H-1B to transition into green card, the employer must have filed a labor certification. So I will need to know what is the priority date of the labor certification. They must have filed I-140. What is the priority date of the I-140? So there are so many things that we, but in the meantime, can you please help me check the priority date for EB2 and EB3? Because H-1B transitioning into green card, it can either be a EB2 or EB3. So we will check that, and let me answer the next question while waiting for that. Oh, okay.
Yeah, I have it pulled up.
So priority date for EB2?
For people in the US, for EB2 is February 2024.
Okay, EB2, the priority date is February 2024.
And then for EB3
For EB3 is April 2023. Now, because this question is talking about H-1B transitioning into green card, this is you are not going to rely on the priority date on the I-140. You can actually use the priority date on the labor certification itself, because labor certification has to be approved before you can file I-130, I-140. So you can use the earlier priority date that is on the labor certification. So just check your priority, your scenario. So is either February 2024 or the EB4 April 2023. So one of the two. Good day, sir. Next question. Good day, sir. Please, this issue has been like this since this date. This must be a continuation.
No.
Which issue?
Okay, he's gonna explain on the next one.
Okay. As of February 21, 2025, we are ready to schedule your form I-485, application to register permanent resident or adjust status, district number. Okay, this has been like this since 2024 that I filed. Kindly advise. Go back a little. Let me see. Was this family based?
I don't think he said
No,
that.
they didn't say.
So we don't know if this is family based. We don't know if this is a NIW. We don't. Well, what is important is look at the processing time. If you look at, I know that for I-485, it's not easy to check the processing time without knowing the local office. So it's not something that we can check for you except we have more information. So, but if you check the processing time, if it is outside of the processing time, then do a service request. Number two, if this is a family-based petition, let your U.S. citizen spouse use congressional intervention. So those are your two options. But if this is employment-based, then check the processing time. If it is outside processing time, you can do a service request. Next question, please.
So remember the person that asked you earlier about having the 48-month extension letter,
Yes.
and that he has now a stamp on his passport?
Yes, and I was saying I don't know whether this is a joint petition or it is a self-petition, good faith marriage or anything like that.
He said, further information and clarification on my answer question. It is a self-petition. I am divorced. Can I still travel?
Oh yes, of course. The only reason I said he should put his house in order is to be sure that the wife knows or his spouse knows the movement. Yeah, he can travel for as long as there is no criminal record.
Okay.
Yeah.
Next one.
Okay. Good day, sir. Thank you for all you do. I came to the US with a J1 visa. I got my EB1A approved. However, my application for waiver of the 212A rule was denied. What option do I have for me to proceed as status adjustment to PR without returning to my home country for 2 years? There is really no option if the waiver has been denied, because the only way for you to be able to adjust is to apply for a waiver of the 2-year foreign residency requirement. But since you have already filed the waiver and the waiver has already been denied, then more importantly, this is employment-based. So you are even going to have another challenge now. If you are not currently maintaining status, unlawful presence is going to set in. But if you are maintaining status, to be honest with you, if you are in legal status, I will go back to my home country, change it to consular processing. For as long as you have not violated your status, you should be fine. Change it back to consular processing. File Form IA-64. Some people are making serious noise there. So file Form IA-24, application for action on an approved petition. Tell USCIS to send the approval to to the consulate and do the consular thing. Because with a J1, marriage to US citizen does not solve the problem. So even if you get married, the problem will still remain. That's the law, 2-year foreign residency. The only way out is to be granted a waiver. And from your statement, the waiver has already been denied. So there is really not much that you can do at this stage other than to do consular processing. On the other hand, if you are already out of status, even consular processing will be denied. So you will need to first file I-601A to clear the unlawful presence waiver. But unfortunately, that will require you having a United States citizen qualifying relative who will have to show that they will suffer extreme hardship if you are to be removed from the United States. So if you are still maintaining status, honestly, your best option is to go ahead and file IA-24 and do the consular processing. There's no way around J1 visa except to get the waiver. And since you have filed the waiver, now let me say this. You say that the waiver has already been denied. The question is, why was the waiver denied? If you are still maintaining legal status, you may want to look at the reason the waiver was denied and then maybe reapply for the waiver. Reapply a second time and try to address the issues. Why? Because I don't know why it was denied, so I can't advise on that. But if you are still maintaining status and you still have time to keep legal status, you can reapply for the waiver. Look at the reason it was denied and try to fix those any problem that they may have pointed out and see. But without a waiver, 2-year foreign residency requirement, there is no way around it. The only other thing you can do is if you are eligible for asylum. That is assuming that you have not even been in the US for more than 1 year. And even with all the things going on with asylum right now, that may not even be a good option. So that's the unfortunate situation.
He sent another message saying that he is in legal status and he does not plan to run out of status. Thank you, sir.
Yeah.
How many more questions?
Oh, how many more questions? Is
Is
this
there-
already?
Oh, it's already. Oh, yeah. We need to.
How many more questions do you want to do?
How many more do we still have? I didn't even realize that time has gone this month.
Many.
Yeah, maybe the next 5.
Okay.
Because already 1:35. We've been on it now for 1 hour 35 minutes. So yeah, we answer the next 5 questions and
Okay.
we continue next week.
So that's the next one.
Okay.
No, I'm coming. I'm
Yeah.
sorry. This is the next one.
No.
This one.
Yes.
Okay. Good day. Why did mother get green card? Father got RFE to prove child-dad relationship. Oh yeah, you should know that. you should know that. Mother carried the baby in her tummy for 9 months. So there's no. I mean, in law we say res ipsa loquitur. It means that the thing speaks for itself because the mother is the one that carried the baby. So there is no question as to who is the mother of the baby. But of course, the father is the presumed father. In law, is the presumed. So you have to prove that you are the father. You have to show evidence of relationship because it is not sufficient to just father a child. You have to show that you are in the life of that child before you can get benefit in the United States. You have to show you are taking care of the child. You are responsible for the child. If you have to pay child support, you are paying it. You are involved in the child's life. You can't just take benefit without doing anything. Men just impregnate women and move on. But the women is the one that will go through the labor and all of that. Yeah, that's why they waive it to women. They don't need any evidence from women to prove paternity or maternity.
So the J1 visa holder, he said the waiver was denied because I was sponsored by my home government.
Did he not get exception? If he get respond, did he not get no objection letter from the home government? That's the reason they have to get no objection letter before applying for a waiver. The home government who sponsor it, if they are the one that is saying that, you know what, even though we spend a lot of money sponsoring this person, but we are not objecting to him staying over there. So if the home government granted a no objection letter, that should be enough.
Yeah.
But let me know if you respond after.
Okay.
I want to know if you obtain no objection letter from the home government. In the meantime, next question. With the immigration situation in the US, what advice do you have for a green card holder who want to travel to Southwest Nigeria for a church program? Will you advise the person to go or watch online? Is there a continuation? Or just okay? Well, the immigration situation does not stop anybody from traveling. I mean, to be honest with you, I'm a Nigerian. I travel to Nigeria all the time, so I don't see any issue since you are not going to areas of concern in the north. But even if you are going, that's not American government problem. That's not what they are looking for. The only thing they are looking for are people with criminal record. Criminal record. That if you don't have criminal record, to be honest with you, if you have a green card, there is no reason for concern. You can go to any country, including Nigeria.
So he did respond again, the J1 visa holder. He said that he did get the no objection letter, but they still denied him.
Well, one thing I can say is that one of the Trump administration policy, which we mentioned at the time, was that wherever an application requires the use of discretion, they should not use the discretion in favor of the applicant. I remember this current administration have that. So they have that. So because waiver is a discretionary application. So even though the home government issued no objection letter, they may have denied it in exercise of discretion. What I will advise this person, two things. Either you decide to go through the consular processing or find a way to keep yourself in status. Hopefully, if you are here legally enough until something change, maybe the government change all these policies, because right now the Trump administration's policy on discretionary issue is that they should not use their discretion. USCIS officers should not exercise favorable discretion in favor of applicants. That is their current policy. So if the home government that sponsor you said they have no objection, so I really don't see why they would deny it except in the exercise of discretion, so which of course is not something that you can contest in court. So either you do the consular processing or just wait. Just make sure you are maintaining status until something change. Yes, ma'am.
So that he'll be glad to reapply through the office if no objection statement is reissued by the home government.
Okay, yeah. If you want to reapply, yeah, we can do that. We can help you with that. Okay, next question. One of my two middle name for my son. One of two middle name for my son was not on my I-485 form. How can I add it while removing condition from 2 years green card? Well, I'm sure that for your son to even get a green card in the first place, 2-year green card, you probably have submitted the birth certificate. And if you didn't, let's assume that the son didn't have green card, because I don't think he mentioned applying for green card. One of the two middle names for my son was not on my I-485 form. How can I add it while removing condition? When you are applying for removal of condition, write the full name and attach a copy of their birth certificate. That's all you need to do.
And maybe on the very last page where it allows you to add comments, they could even explain that he has two middle names and I don't know. Or no.
No, that would be necessary if there is if there's an issue later. If you want to petition for the child later and they bring it up, he can now explain.
at that
But birth certificate will be enough at this stage. Next question. Good day, sir. If your country is among the 19 countries that they ban and you have a pending asylum, is the pause affect you? Yes, sir. Yes, it does. Next question. Okay, that's the one that gave me the meaning of Otijelo. Next question. Hi, and thanks for all you do, sir. If I came to the US as a student and then changed my status to R1, now I'm back in school for nursing while being on R1 status. When I graduate, can I change status?
There's no other question.
There's no other question.
No, that's it.
You've checked.
Yes.
Because this person has raised fundamental issues. And it is important that I spend some time explaining this. If this question, the way it is true, this person is actually out of status as of today. If this fact that is presented here, let me read it again. Hi, and thanks for all you do. No, not that aspect. If I came to the US as a student and then changed my status to R1, now I'm back in school for nursing while being on R1 status. When I graduate, can I change status? The simple answer to this person, based on this information, as of today, you are already out of status. So there is no status to change. You are already, as of today, you are already out of status. Because I just explained a few minutes ago that when it comes to religious status, the word solely is a major factor. If you are on R1, you can only work for your R1 employer. R1 does not authorize you to go to school. So that simply means you have violated the terms and conditions of your R1 by going back to school. You should have changed your status from R1 back to student status, back to F1, and then go to nursing school. But by using R1 to go to school, you are already out of status. You have already violated the conditions of your R1. So, question of changing status upon your graduation does not even arise. So, what I'm going to tell you, I don't know if immigration is aware at this point whether you are in school or not. But what I will do if I'm in your shoes or if you are my client, the first thing I will tell you to do right now, go back to your school and obtain I-20. Obtain I-20 and apply for F1 status. Apply for student status. Although it's going to be difficult because in the service, the school is probably going to report that you are already in school. I don't know how that will work. But, I mean, two things you can do. What I will do, if it is possible to put a pause on the student status, maybe you tell them that you want to defer your admission. Put a pause on it. Go back fully on your R1. Make sure you have pay slip for some months. Have your W-2. We are in December. Have your W-2. Wait till the filing period to file taxes next February. File your tax return. Indicate all the things on R1. After you are fully back on R1 and without you being in school, then apply for a change of status from R1 to F1. Because for F1, you cannot start classes until the case has been approved. So if you are already in classes, even if you apply for a change of status now, it will be denied. Because F1 students are not allowed to commence classes before the status change is approved. So that is why all these things matter. So that will be my advice to you. Next question. Doctor, hello doctor. I'm a naturalized citizen of the USA and I want to file for my mom who has spent about 20 years in the USA. She came in legally though. Is it safe to file for her and what forms? Yes, it is safe to file for her. However, because you stated that your mom has been here for 20 years, I want you to do some preliminary investigation or preliminary inquiry from your mom. Number one, make sure that she has not previously filed anything that may have triggered 204C. Number two, make sure she does not have a prior removal order. And of course, if all of those things check out, then go ahead and submit both I-130 petition and application for green card for your mom. As for the forms, Form I-130, Form I-485, Form I-765, Form I-864. Those are the 4 forms you need to submit on behalf of your mom. But you need to clear those things because somebody who has been here for 20 years, there is a possibility, I'm not saying this is the case, but there is a possibility that she may have filed something in the past. So you want to check out before you file anything, because you may file certain things that can trigger multiple effects. For example, if there is a prior 204C problem, whatever you file is going to be denied, and not only denied, your mom may be placed in removal proceedings. And if she has done something that may have put her in removal proceedings before, maybe like file an asylum which may not have been approved, she may have a removal order. All these things you need to check out. Otherwise, if you file something for her now, that can trigger eyes picking her up. So you want to check these things out. Next question, please. Oh, I saw something. I have a pending. Did I answer that?
Those are our messages.
No. Before this one, scroll down a little bit. Before this one. No, before that. No. Did I answer this? No, I didn't.
Oh, I'm sorry. I missed this one. Yes, I'm sorry.
Is it this one?
That's the one.
Okay.
Mercy.
Okay. Good day, sir. Thank you for all. Okay. Thank you. I have a pending VAWA application. I have received prima facie and also enrolled for biometric, but I have not received the work permit. Please, sir, what can I do? Well, I don't know how long the thing has been pending, whether it's still within processing time. And for VAWA, there is a specific place where you file the employment authorization. So I don't know if you file it at the right place. Can you please help me check the right address to file the VAWA?
It's different locations now based on where you're living. It's no longer, they're sent to lockboxes now.
Oh, okay.
Yeah.
Yeah, so I don't know if it's still within processing time, so you may want to first check the processing time. That's the first thing to check. If it is still within processing time, then you have to wait. If it's outside processing time, you may need to do a service request. But most importantly, you have to be sure that you file it at the right location, because under this Trump administration, before Trump, even if you file in the wrong location, that location will forward the application to the right location. But under Trump, they don't do that. They will just take the application and maybe later deny that it was not filed at the right location. So you want to be sure that it was filed at the right location, and you also want to check the processing time to be sure that it is not within processing time before you can do a service request. Next question, please.
That was the last.
Okay, that was the last one. What's the time? It's almost 2 hours. This is 1:52. Okay, I think we will have to stop here today. As we probably know, this is a live program, and because of that, more and more people join. People will continue to ask questions. So even if we stay here till next day, we will still be getting questions. So we have to stop at a point. you will agree with me that spending 2 hours is a lot of time. So we will have to stop at this time. We hope to continue again next week. Hopefully, I will have time again next week. Today, my case was early in the morning, so that's why we have time. Hopefully, I will not have afternoon case next week. If I do, then the time may be constrained. But in the meantime, we want to tell you to remain vigilant. Make sure that you keep yourself out of trouble. Avoid anything that can bring you in contact with ice, and avoid drinking while driving, DUI. Those are some of the things that can create problems. Try to lay low. I want to assure you that this time will pass. I mean, we survived Trump's first term, so we will survive this one as well. This time will pass, and we will be alive to witness the end of the suffering. God will keep us. I want to remind you to remember to follow us on all our social media podcasts.
TikTok,
Follow us
Instagram,
on TikTok, Instagram, X, YouTube, Facebook.
I think we've listed them all.
And of course, once in a while, when we have updated information, we do send it on reel. So remember to follow all of this and remain blessed. I remain anything.
There's a hearing next week at 1.
Is it in person or WebEx?
Let me see. It says it's in person.
Well, we may have two options: either to start earlier or to do 30 minutes.
I think early works
I think
better.
early is
How
better.
about
Okay.
11 to
So, well, for those of us who are still online, I was just told now that next week I will be in court at 1 o'clock, and it's going to be an in-person. So we may be starting early next week, but we will post the message on our YouTube, on our social media platform. So until then, until next week, I remain yours truly, Dr. Olu Asekun. Thank you again for following us. Thank you for joining us. Remain blessed. See you again next week.